So we're here today with Vince LoBue from Boss Arrighi and Hoag. Wanted to talk a little bit today. Obviously, a lot of consumers impacted by the real estate market and short sales and foreclosures, and there's a lot of improper debt collecting practices going on out there that people need to be aware of. And I think that's kind of one of the things I got off of you guys' website recently was debt collectors coming up with creative and illegal ways to collect, and what the consumer can do to kind of protect themselves in that scenario.
I just want to say good morning, Andrew. I appreciate you having me on the show this morning. Again, my name's Vince. I handle at the firm a lot of our consumer protection cases, and I think one of the things that we do focus on at the firm is taking the consumer protection laws very, very seriously. There's a lot of different things that a creditor or a debt collector can and can't do once someone is represented by an attorney. And it makes it critical if someone's entering into a short sale or attempting to deal with a foreclosure case that they engage an attorney, because with the help of a lawyer, you are eligible and protected by many more laws than you would be if you didn't have an attorney.
And what are some of the sneaky ways debt collectors get around these rules? Like obviously contacting the consumer directly when they're represented, and calling during hours if they're not supposed to call. And what are maybe some of the other things they do?
There's really I guess I would say two types of debt collection violations that you have. First, you have the nasty aggressive debt collector, the ones who will skirt the law to try to maximize their profits and scare people into paying. But I think what's more common that we see is usually the big bank incompetency, for lack of a better term. The big lenders have a hard time with their systems, controlling their ringers, controlling their auto dialers. So under Florida law, it's illegal for anybody to collect on a debt once that person knows they are represented by an attorney.
I remember, it's funny, I remember Chris telling a story to me a while ago about how, and I can't remember which bank it was, but a big bank that was fined multiple times, and then they still kept calling. They're not fined, but they were found in contempt or something, and they still kept calling, even though because the hand didn't know what the foot was doing.
We dealt with a case where a large financial institution was having a hard time with their auto dialer, and even after we had set up a plan to deal with it, they still violated. And then we ultimately resolved the case. One of the things that the bank asked us for, and we were happy to give because it helps our client, was if we continue to call, please give me a heads up, because we understand that our auto dialer is hard to turn off. So we would like the ability to fix it in case anything happens in the future. I've also run into a number of incidents where I have had to sue not only a third-party debt collector for collecting on debt that isn't owed, another illegal debt collection practice in the state. So if you've already closed on a short sale and you have a third-party debt collector collecting when they're not supposed to, that's definitely something we can investigate in violation of state law. But I've had to sue a third-party debt collector and then a fourth-party debt collector for continuing to collect on debt that wasn't owed. So it's almost the difference between the legal and the practical realities. Legally, people, and more often than not in a short sale, relieve themselves of the debt. Practically, they collect on debt they're not supposed to.
Makes sense.